Imagine getting a phone call that your father has passed away, and somewhere in the middle of your grief, someone hands you a stack of papers and says, "This has to go through probate. You don't know what that means. You don't know how long it takes. And you definitely don't know what it's going to cost." For a lot of families, that's the moment they realize estate planning wasn't just paperwork, it was protection, and the price of not having it in place can be far higher than anyone expects. Here's something that surprises almost everyone the first time they hear it. Probate costs are not the same everywhere in this country. A modest estate that costs a few $1,000s to settle in one state could cost tens of thousands of dollars in another. Same size estate, same basic situation, wildly different price tag depending entirely on which state that person happened to live in or own property in when they passed away, and most families don't find this out until they're already living it. This is general education, not legal or financial advice. I'm not an attorney, and I'm not a financial advisor. What I am is someone who has spent a lot of time researching how probate actually works across the country, so that you can walk into a conversation with a licensed professional already understanding the landscape. Because probate law is set at the state level, and it genuinely does vary, sometimes in small ways, sometimes in ways that can cost a family real money and real time. So keep that in mind as we go through this together. By the end of this video, you're going to understand what actually drives probate costs, why some states are dramatically more expensive than others, what percentage-based fees can quietly do to an estate's value, and what kinds of planning tools exist to help families avoid or minimize these costs. If any of this feels new or a little overwhelming, that's completely normal. Most people never think about this until it's already happening to them. So if you find this helpful, consider subscribing, because we cover exactly this kind of practical, plain English estate planning education every week, and this is the kind of thing you want to already know before you need it. Let's start with the basics of what probate actually is, because you can't understand the cost until you understand the process. Probate is the court-supervised process of settling someone's estate after they pass away. It's how a will gets validated, how an executor gets legal authority to act, how debts and taxes get paid, and how what's left gets distributed to heirs. In theory, it sounds fairly straightforward. In practice, it can take anywhere from a few months to well over a year, and every step along the way tends to come with a cost attached. Those costs generally fall into a few categories. There are court filing fees, which are usually fixed and relatively small, often a few $100s, though this varies by county as well as by state. Then there are executor fees, which compensate the person managing the estate for their time and effort. Then there are attorney fees, which in many states are the single biggest cost driver. And finally, there are miscellaneous costs, appraisals, accounting fees, bond premiums, and the like, that add up more than people expect. Here's where it gets interesting, and where the real state-by-state differences show up. Some states allow, or even encourage, what's called a percentage-based fee structure for executors and attorneys. California is probably the most well-known example of this. California law sets out what's often called a statutory fee schedule, where both the executor and the attorney can each be paid a percentage of the estate's gross value, not the net value after debts, the gross value. That percentage starts around 4% on the first $100,000 and steps down from there, but it applies separately to both the executor and the attorney, and it's based on the size of the estate before any debts are subtracted out. Let's put a real number on that so it's not abstract. If someone in California owns a home worth $600,000, and that's essentially the whole estate, a percentage-based structure like this can result in tens of thousands of dollars in combined executor and attorney fees, even if there's a mortgage still owed on that home, because remember, the percentage is often calculated on the gross value, not what's actually left after debt. That's a number that shocks a lot of families because they assumed probate would cost a few $1,000s, not a meaningful chunk of the estate itself. Now compare that to a state like Texas, which allows for what's called independent administration in many cases. This is a simplified probate process where the executor can act with much less court supervision, which generally means fewer required filings, fewer hearings, and lower attorney involvement, and therefore lower cost. In a state with this kind of streamlined process, the same $600,000 estate might cost a few $1,000s to settle instead of tens of thousands. Same estate, same family situation, completely different financial outcome, purely based on geography and the applicable state statute. This is exactly why I keep saying laws vary by state, because it's not just a disclaimer, it's the single most important fact in this entire topic. Some states charge flat or hourly attorney fees instead of percentage-based fees. Some states have small estate thresholds that let modest estates skip formal probate altogether, using a simplified affidavit process instead. Some states are known as more efficient, lower-cost probate states, often because their court systems are less backlogged and their statutes don't mandate percentage-based compensation. And some states are known for the opposite, slower courts, more required steps, and fee structures that eat into the estate. Let me tell you about a situation that illustrates this well. Imagine a family, we'll call them the Whitfields, purely as an illustrative example, where a father passes away owning a home, a car, and a modest retirement account, altogether worth around $500,000. He had a will, but no trust, and no other planning in place. His two adult children assumed probate would be quick and cheap, because the estate wasn't especially large or complicated. Because he lived in a state with percentage-based attorney and executor compensation, and no living trust to root the property outside of probate, the process took over a year, involved several court filings, and the combined fees ended up being a meaningful percentage of the estate's total value. The siblings were left wondering why nobody had told them this was a possibility. That's the gap this video is trying to close. Not to scare you, but to make sure you're not the family finding this out for the first time in the middle of a loss. Let's talk about what specifically drives these costs up, because it's not just which state, it's a combination of factors working together. The first is estate size. Larger estates generally mean higher percentage-based fees, where those apply, and more complexity for the court to review. The second is whether real estate is involved, and how many properties, because real property often requires appraisals and sometimes court approval to sell, which adds both time and cost. The third is whether the will is contested, because any dispute among heirs can turn a routine probate into a drawn-out legal battle, and legal battles are expensive by nature. The fourth is whether the executor lives out of state, since that can complicate administration and sometimes requires additional bonding. And the fifth, which people underestimate, is simply how backlogged the local probate court is. Some counties move through cases in a matter of months, others take well over a year, purely due to court capacity. It's also worth understanding the different fee models you'll encounter, because attorneys generally bill in one of three ways for probate work. Some charge a percentage of the estate, similar to what we discussed with California. Some charge flat fees for straightforward, uncontested probate cases, which can offer more predictability, and some charge hourly rates, which can be more or less expensive, depending on how complicated the estate turns out to be. When you're speaking with an attorney in your state, it's worth directly asking which fee model they use and getting that in writing, because that single conversation can save a family a significant amount of money and a significant amount of uncertainty. Now let's talk about why this matters so much for planning ahead, because this is really the heart of the issue. A revocable living trust is one of the most common tools used specifically to avoid probate altogether for assets placed inside it. When a home, investment accounts, or other property is retitled into the name of a trust during someone's lifetime, those assets generally bypass the probate process entirely when that person passes away, because the trust already has built-in instructions for who receives what, without needing a court to validate a will and supervise distribution. This doesn't eliminate every cost. There's typically an upfront cost to set up the trust properly with an attorney, but for many families, especially those in high-cost, percentage-fee states, that upfront investment can end up being far less than what probate would have cost later. Beyond trusts, there are other tools that help specific assets avoid probate, regardless of which state you're in. Beneficiary designations on retirement accounts and life insurance policies allow those assets to pass directly to the named beneficiary, outside of probate, as long as those designations are kept up to date. Payable on death and transfer on death designations can do something similar for bank accounts and, in many states, for real estate and vehicles. Jointly owned property with rights of survivorship can also pass directly to a surviving co-owner without going through probate. None of these tools replace the need for a comprehensive estate plan, and none of them are a one-size-fits-all solution, but together they represent the main strategies families use to reduce their exposure to whatever their state's probate costs happen to be. Let's clear up some common misconceptions, because there's a lot of confusion floating around this topic. The first myth is that having a will avoids probate. It doesn't. A will actually has to go through probate to be legally validated and enforced. A will is a set of instructions for the probate process, not an alternative to it. The second myth is that probate costs are the same everywhere, which we've spent this whole video disproving. They can differ by tens of thousands of dollars for a similar-sized estate, purely based on state law and county court practices. The third myth is that only wealthy families need to worry about this. In reality, even modest estates, especially ones that include a home, can face meaningful probate costs in high-fee states, which is exactly why this topic matters for regular families, not just for the ultra-wealthy. And the fourth myth is that trusts are only for the rich. Living trusts have become increasingly common among middle-class families, specifically because of situations like the one we just walked through, where avoiding probate fees and delays provides real, tangible value regardless of someone's overall net worth. So what can you actually do with this information? Start by finding out your state's probate process and fee structure. A licensed estate planning attorney in your state can walk you through exactly how your state handles executor compensation, attorney fees, and whether a simplified process is available for smaller estates. Next, take an honest inventory of what you own, including real estate, retirement accounts, bank accounts, and any other significant assets, because the right planning tools depend heavily on what you actually have and how it's titled. Review your beneficiary designations on every account that allows them, and make sure they're current, especially after major life events like a marriage, divorce, or the birth of a grandchild. If you own real estate or have a moderate to high net worth, have a real conversation with an attorney about whether a revocable living trust makes sense for your specific situation and your specific state. And finally, don't wait for a crisis to have this conversation. The families who plan ahead of time are almost always in a far better position than the families who are figuring this out for the first time while grieving. At the heart of all of this is something pretty simple. Nobody wants to leave their family with confusion, delay, and unexpected costs during one of the hardest moments of their lives. Estate planning isn't really about money, even though we've spent a lot of this video talking about dollars and percentages. It's about protecting the people you love from unnecessary stress at exactly the moment they can least handle it. Knowing how probate works in your state, and knowing what tools exist to make that process smoother, is one of the most caring things you can do for your family, long before they ever need to use that knowledge. If this video helped you understand probate costs a little more clearly, do me a favor and subscribe, because we publish videos just like this one every single week. Practical, plain English breakdowns of wills, trusts, probate, and everything in between, made for people who want to actually understand this stuff, not just be talked at by legal jargon. And as always, everything in this video is general education, not legal advice. Estate laws vary from state to state, so before you make any decisions, please talk to a licensed estate planning attorney in your state. Thanks for watching, and I'll see you in the next one.